Ms. Johnson, do you have any further statements regarding the evidence presented?
Yes, Your Honor. I would like to clarify some points about the timeline of events.
Courthouse rose from the block like a decision already made. Its facade was limestone and glass. Pale in daylight, colder in shadow, and architecture designed to look neutral while it separated people with surgical precision. The entrance was a mouth that did not smile. A revolving door turned with the slow patience of something that knew it would outlast everyone who passed through it. She approached alone, not hurried, not hesitant. A steady pace that refused to apologize for occupying the sidewalk. The blazer sat slightly loose at the shoulders, borrowed, pressed carefully to look casual, navy fabric. A school crest stitched near the breast like an inherited lie. The skirt was modest, the tights plain. The shoes dull with ordinary used black flats scuffed at the toe. The kind of scuff that came from walking because you had to, not because you were training for anything. The scuff caught the winter light like a small confession above the door. The seal of the state stared down with a stylized seriousness. Inside, the lobby waited. The air changed immediately. Outside air had wind in it, a direction. Inside air was filtered into obedience, cool, odorless, and shared by too many bodies without belonging to any of them. The ceiling climbed high and blank, fitted with recessed lights that made the stone floor shine like wet pavement. Every surface was designed to endure touch without acknowledging it. On the far side of the lobby, security had been positioned like theology. Metal detectors stood in a row, matte black, rigid as doctrine. Conveyor belts fed into X-ray machines that swallowed purses and backpacks and returned them stripped of innocence. A stanchion maze funneled people into lines that curved and tightened like a lesson. You moved where you were told, and you waited. Above the archway, a sign in official font listed forbidden items: knives, aerosol cans, firearms, as if danger arrived only in objects and never in judgment. She stepped into the line and watched the room. A man in a suit rehearsed his face in the reflective glass of a column. A woman with a stroller shifted her weight, eyes darting toward the guards as if any sudden movement might be interpreted as guilt. To teenagers, actual teenagers, stood with their hands in their pockets, leaning into their phones, oblivious, in a way the building would soon correct. A public defender in rumpled gray passed through a side door without stopping, a badge already hanging from his neck like an amulet. She didn't have that badge. She had a lanyard, but it was empty. Its clip clicked softly against her zipper with each breath. An unassigned hook waiting for authority to be granted. She held a slim file in one hand and a small purse in the other. No backpack. Nothing that could be read as too much. Her posture stayed upright, shoulders down, chin level. She looked neither defiant nor grateful. She looked prepared. The guard at the front of the line wore a uniform that had been washed so many times the seams had softened. His belt carried tools that announced his power even when he did not speak. He watched people the way one watches weather, with an expression that suggested inevitability. When her turn came, he didn't nod. He didn't say good morning. He looked at her shoes first. The scuffed toe met his gaze like a challenge it had not intended to make. Then his eyes climbed, slow and evaluative, stopping at the blazer crest. He took in the clean lines of her hair, the quiet face, the calm. He did not ask what hearing she was attending. He did not ask if she was counsel. He asked the question that assumed the answer. School got you out early, he said. The words didn't carry open hostility. They carried something more useful, permission for everyone else in the line to decide what she was without evidence. He let the sentence hang, a small hook set into the air, waiting for her to take it. She did not smile. Court, she replied. One word, no explanation, no added softness. The guard's eyebrows rose as if the building itself had spoken out of turn. Take everything out your pockets, he said, louder than necessary. Shoes on the mat, belt off. I'm not wearing a belt, she said. He blinked, irritated by the correction, then pointed at the bins as if he hadn't heard. She emptied her purse, keys, a pen, lip balm, a folded list of names and numbers. She placed the file beside the bin, but did not let go of it until the last possible second, fingers lingering on the edge like she could transfer certainty into paper. The metal detector waited. It was a narrow gate framed by light, a corridor without mercy. People walked through it one by one, arms raised in the ritual posture of surrender. The machine did not care who you were. The people operating it did. She stepped forward, hands slightly out, palms open. The guard watched her move the way one watches someone approach a border. The detector beeped immediately, a sharp, clean sound, unemotional, final. The line behind Her shifted, impatience turning into attention, eyes lifted, then quickly lowered. No one wanted to be close to complication. The guard's mouth tightened. Back, he said. She stepped back. The beep had already done its work. It made her visible in the worst way. The guard motioned with two fingers for a secondary wanding. His colleague, a bailiff in a darker uniform with a star pinned to his chest, approached, the handheld scanner already in his grip. The bailiff's gaze skimmed her face and stopped at the blazer crest, as if it were evidence of a crime. You got anything on you? He asked. No. He began at her shoulders, sweeping the wand down with the precision of a man who had done this 1,000 times, and still believed each pass could reveal something essential about a person. The wand hovered near her ribs. It chirped at her left hip. What's that? He said. She reached into her pocket and pulled out a small object, a bar card holder. Not the card itself, just the sleeve, clear plastic, slightly scratched from use. It was empty. The bailiff took it from her fingers as if confiscating contraband. He turned it over, squinting, searching for meaning where there wasn't any. His thumb pressed into the plastic hard enough to leave a pale crescent. Why you carrying an empty badge holder? He said. She held his eyes for a beat. The kind of beat that made silence feel like a verdict. Then she answered, because I wasn't issued mine. The bailiff's expression flickered, something like amusement, something like annoyance. He did not ask who should have issued it. He did not ask why. He looked past her to the guard. And in that small glance, a decision passed between them. Without language. They did not trust her. Trust was not a default here. It had to be earned through the correct signals, the right haircut, the right age, the right skin, the right suit. She had only one of those things, and it wasn't enough. The bailiff handed her the empty sleeve back, but not gently. It snapped against her palm. You can go, he said, but you need a visitor badge. It was said as if it were a kindness, as if it were policy, as if it weren't an additional strip of fabric meant to mark her as someone to watch. He led her to a small desk tucked against the wall, where a clerk sat behind plexiglass and a narrow slot. The desk was designed for transactions that did not include dignity. A stack of temporary badges lay on the counter like paper tags for livestock. The clerk looked up, bored, and then looked down again as if she had already been categorized. Name, the clerk said. She gave it. Clear, even. The clerk typed slowly. The keyboard clicks echoed in the hard lobby, every keystroke amplified by stone. The printer whirred, and a badge slid out, glossy and white, with block letters that were too large to ignore. Visitor. Her name beneath it misspelled by one letter. The clerk did not notice, or noticed and didn't care. She pushed the badge through the slot with a plastic lanyard attached, the cheap clip already bent. The bailiff took it and clipped it to the lapel of her borrowed blazer himself. An intimacy performed as control. The clip tugged the fabric, pulling the crest slightly off-center, a small displacement, a small correction. There, he said. Now you can sit in the gallery. They'll call you if they need you. He didn't ask if she was expected. He didn't ask why she was here. He told her where her body belonged. The badge hung against her chest, bright and wrong. The word visitor made a statement the building was eager to enforce. The misspelling made it worse, as if even her name had to be trimmed down to fit the system's mouth. She touched the badge once, two fingers pressing lightly against it, then dropped her hand. She did not try to fix the letter. She did not ask for it to be reprinted. Corrections here were never free. They always cost something: time, tone, humility. She walked deeper into the courthouse. The hallway beyond security was narrower, quieter, lined with framed photographs of judges and donors, all of them smiling with the confidence of people who had never had to prove they belonged in the room. The floor changed from polished stone to industrial carpet that dulled footsteps. The lights remained fluorescent, steady and indifferent, bleaching color from skin and fabric alike. A door opened somewhere to her left. A man in a suit stepped out, laughing softly into his phone. His laugh was casual, unpunished. He didn't look at her. He didn't have to. The building already recognized him. She followed the signs: courtrooms 3 to 8, hearing rooms, clerk of court, teach arrow directing her into deeper layers of formality. A bailiff at a hallway checkpoint glanced at her badge and pointed without speaking. Public seating. His gesture said. She went where the gesture sent her. The courtroom doors were heavy, wood darkened by years of contact, each door handle polished by the hands of people who believed the law was something you entered and exited like a room. She paused outside one door marked courtroom 5 and listened. Inside, voices murmured, papers rustled. A cough, the soft thump of a binder closing. The sound of a microphone being tested, one small pop, then silence, as if the room were clearing its throat to speak. She opened the door and stepped into the hearing chamber. The air inside was colder. The architecture was familiar to anyone who had ever been judged. The judge's bench elevated, the flag standing like stiff witnesses, the seal behind the bench like a halo made of law. Counsel tables face forward like kneeling positions. The public benches sat behind a low wooden barrier, a boundary designed less for security than for hierarchy. She walked toward the front, instinct, purpose, then stopped when a bailiff's gaze cut her in half. He looked at her badge. Visitor. His eyes did not lift beyond it. He pointed toward the back benches. No words, just direction. She went. Each step felt measured, not by her, but by the room. The floor did not creak, it absorbed. The fluorescent lights did not flicker, they held steady, flattening everything into the same sterile brightness. She slid into a seat on the first row of the public gallery, file balanced on her knees. The borrowed blazer's crest sat slightly crooked, tugged by the badge clip. The misspelled name rested over her heart like an accusation. She sat perfectly still. The room filled around her, the prosecutor at one table arranging documents with relaxed ownership, the court clerk organizing stacks with brisk neutrality, the stenographer testing keys with quick, private taps. At the far end, the judge's chair remained empty, looming like an unoccupied threat. Her fingers rested on the edges of her file. She didn't open it yet. She didn't look down. She looked forward at the bench, at the microphone, at the space where power would soon arrive and begin speaking as if it were truth. The badge shimmered under the fluorescent light. Visitor. It meant watched. It meant temporary. It meant not entitled to speak unless spoken to. In the quiet before court began, the courthouse did what it always did. It sorted. It labeled. It trained bodies to accept their assigned posture, and in that training, subtle, constant, rehearsed like a hymn through metal and light, the system revealed itself not as a place where justice happened, but as a place where belonging was rationed. Outside, the city moved without knowing this room existed. Inside, a door behind the bench clicked open. The judge was about to enter, robe swaying like a curtain, and the building, with its clean floors and cold lights and misprinted badges, waited to see whether she would submit to the role it had pinned to her, or whether she would make the room rewrite its own assumptions. The courtroom did not begin with a gavel. It began with waiting. A bailiff's finger, a quarter, a door that closed behind her with the soft finality of policy. These were the opening rites. The hearing chamber had been to public for what the building wanted from most people. It wanted them softened first. It wanted them quiet. It wanted them trained into the correct shape. The waiting room sat adjacent to the courtrooms like an antechamber to confession. Windowless, low ceiling, walls painted the color of old paperwork. Fluorescent lights ran in long panels above, humming with a thin electrical impatience that never stopped. Their brightness was not generous. It was corrective. It erased shadow. It erased softness. It erased the small mercies of dimness that allow a face to be privately human. There were chairs bolted to the floor in rows, molded plastic with shallow curves, designed to hold bodies without comforting them. The bolts were visible silver circles punched through the legs, each one a reminder that even furniture was not trusted to move freely here. She sat at the far end, back straight, file on her lap. The visitor badge rode her lapel like an error that refused to resolve. It caught the overhead light whenever she breathed, flashing visitor, 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 an unwanted metronome across from her. Men and women waited in the postures of people who had already been instructed, heads bowed not in prayer but in preemptive surrender, hands folded tightly as if the fingers might attempt escape, knees pointed forward, feet planted. A few whispered into phones with the volume of someone asking permission to exist. No clocks. There were posters, court etiquette, prohibited behavior. A smiling cartoon judge reminding you to be respectful, but no clock face, no digital read out. Nothing that would allow a person to measure how long their life was being held in the building's mouth. The absence wasn't accidental. Time was the first thing the system confiscated. Without it, people became pliable. Without it, they could be told anything and believe it. She watched. A young man in a wrinkled hoodie sat with his elbows on his knees, hands clasped so tight the knuckles blenched. His gaze stayed fixed on the floor as if looking up might be interpreted as aggression. Next to him, an older woman held a stack of documents in her lap. The pages bent and softened at the corners from anxious rereading. She kept smoothing the top sheet like she could iron her way into being believed. Every few minutes, a door would open. A name would be called. Someone would stand to quickly, shoulders hunched, eyes darting. They would disappear through the doorway and return later, changed, sometimes lighter, sometimes hollow, sometimes with their dignity rearranged into a smaller shape. The fluorescent lights did not change. They did not acknowledge relief. They did not witness grief. They only hummed. She opened her file for the first time. Paper smelled like dust and toner. The pages were clean but already heavy with consequence. Incident reports with copied language. Police narratives written in the grammar of certainty. Forms filled out by clerks who did not know the people represented by the boxes they checked. In the margins, she had written notes in small, tidy strokes. Not arguments, anchors, dates, statutes. A line of questions that would turn assumptions into admissions. The building wanted her to be a spectacle later. But for now it treated her as a clerical mistake. A television mounted in the corner played muted news. Captions rolling beneath a smiling anchor who talked about traffic and weather in something called public safety. The captions moved quickly, too fast to follow comfortably. Even the information that was supposed to help was delivered in a way that kept you behind. She looked up as a door opened again. A public defender stepped into the waiting room, scanning faces like a medic trudging after a storm. His suit was one size too big, his tie loosened, his eyes tired in the particular way of someone who had learned to ration empathy without letting it die. He carried a paper cup of coffee that had long since lost its warmth in his other hand. A battered folder. He paused when he saw her, not because he recognized her, because her presence didn't fit his mental map of the room. Young face, borrowed blazer, visitor badge, file in her lap held like it mattered. He approached cautiously, lowering himself into a chair to seats away, leaving a polite gap that still carried suspicion. He angled his body slightly toward her, voice low. "You here with family?" he asked. Question sounded gentle, but it carried a presumption. He was offering her a role the building understood. Sister, daughter, worried cousin. Someone who would sit quietly and accept what happened to the real participants. "No," she said. "I'm here for the case." He exhaled, half a laugh without humor. "Court's not a field trip," he said. Silence followed, thickened by the overhead hum. She did not correct him right away. She let the space hold his assumption. Let it reveal itself fully. He glanced at the file again, the way a man glances at a locked door and wonders if it's worth trying. "You got counsel?" he asked. "Hi. AM counsel," she said. It was calm, not boastful, not defensive. A statement the way a locked fact is a statement. He blinked. The fatigue in his eyes shifted into focus, as if he'd been handed a new variable in a calculation. "Okay," he said slowly. "Then why are you wearing a visitor badge?" She looked down at it once, not with shame but with a kind of cold. Documentation. The misspelled letter sat there like an injury the system would deny it caused. "Because someone decided I was a visitor," she replied, before asking. The public defender's jaw tightened, a tiny movement, almost imperceptible, as if he had just bitten back something older than this moment. He leaned forward, elbows on his knees, coffee cup cradled like a fragile truth. He didn't apologize for the system. He didn't make excuses. He gave what he could afford, a warning. "Don't antagonize the judge," he said. One sentence. Not advice, not a suggestion. A survival rule delivered with the flatness of someone who had seen what happened to people who broke it. She watched him as he spoke. The lines on his face were mapped by repetition. Too many hearings, too many defendants who thought they could explain their humanity into being spared. Too many judges who treated mercy like a personal inconvenience. What counts as antagonizing? She asked. He looked at her then, really looked. He took in her posture upright, contained. Her hand steady, her face young enough to invite disrespect, composed enough to warn against it. "Standing tall," he said, correcting him. "Speaking like you belong." He paused, the corners of his mouth turning down. Sometimes just existing the wrong way. The room absorbed that. The fluorescent lights hummed in agreement. Across the waiting room, the young man in the hoodie had started whispering to a woman who might have been his mother. His voice was too low to catch, but his hands gave him away. He kept rubbing his palms over his knees, as if trying to erase sweat, as if trying to erase himself. A clerk opened the door again and called a name. The young man flinched at the sound, even though it wasn't his. His body reacted as if the building had spoken directly to him. Everyone in the room, for a moment, became smaller. This was the ritual. Not the law. The law was printed in books and posted on websites. The ritual was what happened here. Bodies trained into compliance. Voices trained into softness. Eyes trained into downcast angles. The ritual taught people that dignity was negotiable and submission was practical. She closed her file gently, not because she was finished, but because she had seen enough to understand what she was walking into. The public defender stood, his knees cracking softly. He adjusted his tie with a tired hand and looked at her badge again. As if the word visitor offended him in a personal way, he didn't offer to fix it. He knew better than to promise that kind of repair inside these walls. Before he left, he spoke again, quieter. "They don't like surprises," he said. "And they really don't like being wrong." "I'm not here to surprise them," she replied. "I'm here to correct the record." That made him still for a beat. The hum of the lights seemed louder, the air slightly colder, as if the room itself had taken offense at the word correct. Then he nodded once, small, restrained, an acknowledgement of something he couldn't afford to say aloud. He walked out through the door and disappeared into the corridor where the real work of managing outcomes took place. She stayed, waiting, again, with the file on her lap, badge flashing its wrongness. The room had no clock, but she could feel time in the way shoulders sagged, in the way apologies were rehearsed under breath like prayers. She could feel it in the silence between names called, in the way that silence was used as a tool, stretching, thinning, making people willing to accept whatever came next just to escape the uncertainty. A woman across from her whispered, "I'm sorry," over and over into her hands, practicing for someone who had not yet asked. A man near the door kept standing, sitting, standing again, as if movement could bargain with fate. She remained still, not because she was unafraid, because fear was what the building expected from her. Fear was the posture it had prepared for her, the posture it would reward with tolerable treatment. She did not give it that satisfaction. The fluorescent lights flattened every face into the same exhausted color, but they could not flatten intention. They could not erase the moral line forming inside her with each breath. The difference between being quiet because you are respectful and being quiet because you have been trained to disappear. Outside the waiting room, behind locked doors and frosted glass, the court ran on schedules no one in this room could see. Cases moved like inventory, lives were processed with the efficiency of paperwork. And in this place with no clocks, where time was withheld like a punishment, the system did what it was designed to do. It kept people uncertain so they would mistake compliance for safety. The door opened again. A name was called. Not hers, not yet. The waiting continued, and the building held its breath, confident that eventually everyone would learn the lesson it was built to teach. Court did not begin with law. It began with performance. The bailiff's voice cut through the waiting room, flat, practiced, unarguable, a list of names, a direction. Chairs scraped softly as bodies stood and followed, pulled by the promise that waiting might finally turn into release. She rose with the others, file tucked under her arm, badge catching the light as if eager to announce her status again. The courtroom swallowed them whole. Inside, the space had been reset while they waited, chairs aligned, microphones angled just so, water pitchers filled and untouched. The flags stood in their corners like props that had memorized their marks. The judge's bench loomed at the far end, elevated enough to require a tilt of the neck and architecture that demanded deference. Before a word was spoken, the judge entered from behind the bench through a door that closed softly behind him, sealing the room like a verdict. His robe moved with practiced ease, black fabric heavy with authority, sleeves hanging just long enough to suggest restraint. He did not rush. He allowed the room to adjust itself around his presence. Everyone stood. She stood with them, back straight, eyes forward. The visitor badge lay flat against her chest, the misspelled name still intact, still uncorrected. "Be seated," the judge said, already smiling. It was not a warm smile. It was a smile trained for public service, pleasant, controlled, selective. It landed comfortably on the prosecutor, who returned it with the reflexive gratitude of someone whose place in the room was secure. It did not land on the defendant, whose shoulders curved inward as if bracing for weather. The gavel came down once, not hard, not soft, a measured tap that announced time had been captured. The clerk called the case. Names filled the room like labels. The defendant stepped forward, cuffs glinting briefly under the fluorescent lights before a bailiff guided him into place. The judge glanced at him, then at the paperwork, then back at the room. And then the judge noticed her, not all at once. First the badge visitor, too bright, too large, then the blazer crest, then the shoes. The scuffed toe again, refusing to disappear. His smile shifted, recalibrating. The performance found a new prop. "Well now," he said, leaning back slightly in his chair, robe settling around him like a curtain. Looks like we've got a field trip today. A ripple of sound moved through the courtroom. Not laughter yet, anticipation. People recognized the opening cadence of a joke and prepared themselves to participate. She did not move. The judge tilted his head, peering over the bench as if adjusting his vision. "Young lady," he said, "you lost." The question did not seek an answer. It was an invitation for the room to enjoy the moment. His tone was light, teasing, almost kind cruelty dressed in civility. She remained standing, silent, eyes forward, the file pressed against her ribs like a second heart. The judge chuckled softly. "Is this one of those career day things?" He continued, "You planning to be a lawyer when you grow up?" Laughter bloomed, quick and uneven. It came from the safe places. First the prosecutor's table, a few clerks, someone in the back who wanted to be counted among the agreeable. The laughter wasn't joyful. It was strategic. It said, "I understand the rules. I know when to laugh." The defendant did not laugh. He stared at the floor. The judge raised a hand, palm out, enjoying his control of the room. "Relax, everyone," he said. "I'm just asking. Court can be intimidating for kids. Kids." The word settled on her shoulders like a verdict delivered. Without evidence. She inhaled once. Slowly, she did not speak. Silence, in this room, was already resistance. The judge's smile tightened. "Well," he said, "you going to tell us why you're standing up there instead of sitting in the gallery?" He gestured vaguely toward the public benches, as if they were the natural habitat of her kind. His eyes flicked to the bailiff, who shifted his weight, prepared to assist. Before she could answer, the judge continued, his voice carrying the practiced rhythm of a man accustomed to uninterrupted speech. "Because last I checked, this table," he tapped the bench with his pen, "is for counsel, not visitors, and certainly not students skipping class." More laughter, louder this time. The room responded the way a room does when power offers humor as a safe outlet. People laughed because not laughing would mark them as difficult. People laughed because silence would suggest complicity with the wrong person. The microphones picked it all up. Black foam heads perched on thin stems, angled toward the judge, toward the prosecutor, toward anyone whose voice mattered. They amplified the judge's tone perfectly, every chuckle rounded, every word clear. They did not amplify the silence of the defendant. They did not amplify the tightness in her chest. They amplified power. She spoke, then not loudly, not quickly. "I'm here for the hearing," she said. 6 words. Calm, measured, not defensive, not apologetic. The judge arched an eyebrow. "Well, that's good," he said, "because we're having one." More laughter, a rhythm now, call and response. "But you still haven't told me," he continued, leaning forward slightly, elbows on the bench, lowering his voice as if sharing a secret with the room. "Why you think you get to stand where you're standing?" "Think. Get to." The language was deliberate. It framed her presence as entitlement, not right, as assumption, not fact. She felt the room watching her, not with curiosity, but with expectation. They expected embarrassment. They expected retreat. They expected the choreography they had seen 100 times before. The head lowering, the apology offered, the body guided back into its assigned place. She did not give it to them. "I'm counsel," she said. The words landed differently this time. Not because they were louder, but because they contradicted the script for a moment. The room hesitated. The judge laughed short, sharp, dismissive. "That's a good one," he said, very confident. "You practiced that in front of a mirror." The prosecutor smiled politely, eyes flicking between the judge and her badge. The bailiff shifted closer, hand resting lightly near his belt, not threatening, just ready. The judge tapped the gavel once, a metronome correcting tempo. "Okay," he said, "let's have some fun. Shall we?" Fun. The word hovered over the room like a warning. "Name?" he asked. She gave it. He glanced at the clerk, who typed, paused, typed again. The keyboard clicks sounded louder than they should have, amplified by the quiet that had replaced laughter. The clerk frowned at the screen, leaned closer, adjusted her glasses. The judge watched, still smiling, but the smile had begun to thin. "No record," he said lightly. Before the clerk could speak, "Must be a glitch." The clerk cleared her throat. I'm still loading, Your Honor." The judge waved a hand. "Well, take your time," he said. "We've got all day." Or maybe she's late for algebra. A few laughs again, weaker now, uneven. The room sensed a shift but didn't yet know what it meant. She stood perfectly still, eyes on the bench. The badge lay flat against her chest. Visitor screaming its wrongness into the microphone's indifferent ear. The judge leaned back, robe folding around him. And for a moment his elevation felt less like authority and more like distant space that could not be crossed without consequence. No, he said, still smiling. Confidence is a good thing. But there's a line, and this, he gestured at her, is crossing it. The courtroom held its breath. Not because the law was about to speak, but because authority was deciding how much humiliation it could extract before it had to check the record. The gavel rested under the judge's hand, ready to tap again to mark time, to keep the rhythm of a system that knew exactly how to turn cruelty into ceremony. And in that clean, orderly room where microphones favored some voices and not others, where elevation masqueraded as wisdom, the performance continued. Authority did what it always did. It smiled, and it waited for the room to agree that the joke was funny. Judge did not raise his voice. He did not need to. Authority in this room lived in the casualness of command, in the way a sentence could be delivered as if it were already agreed upon. He leaned back in his chair, smile fixed in place, and glanced at the bailiff like a conductor cueing an instrument. Let's keep things orderly, he said. Bailiff, why don't you help our visitor find a seat in the gallery? Double quotes visitor. He said it carefully. Slowly, each syllable placed with intention, like evidence entered into the record. His eyes flicked once, just once, to the badge on her lapel, as if reading it aloud even before he spoke it. The bailiff stepped toward her. He was close enough now that she could smell his cologne, something sharp and clean, chosen to announce professionalism. His presence blocked part of her view of the bench, a human wall that turned command into action. He did not grab her. He touched her elbow. The fingers, light pressure, polite. The kind of contact designed to feel reasonable even as it removed choice. The kind of touch that could later be described as assistance if anyone asked. This way, he said quietly. She looked down at the point of contact, then back up at the bench. The judge had already turned his attention to the clerk. The moment dismissed as efficiently as it had been created. The room waited to see how she would comply. She did not speak. She did not pull away. She did not stiffen dramatically. Resistance here did not look like refusal. It looked like dignity held under instruction. She took one step back, then another. The file folder stayed pressed against her ribs, her fingers curled to tightly round its edge. The cardboard bent slightly under the pressure, a small crease forming near the corner, an injury no one else would notice. As she moved, the bailiff glanced down at her badge, the word visitor bright and unmistakable. He read it aloud, not loudly, but clearly enough for the microphones to catch. Visitor, he said. He paused, then added her name, mispronounced, the wrong vowel stretched, the emphasis misplaced. A minor error, easily corrected, easily ignored. She did not correct him. Correction, here, would have been framed as defiance. Correction would have been another disruption. The system was fluent in turning accuracy into attitude. She walked to the gallery. The public benches received her the way they received everyone else, without welcome, without acknowledgement, wood polished smooth by years of folded hands and restless shifting. She slid into the first row again, posture unchanged. Files still clutched like a shield. Behind her, she felt the room exhale. The laughter did not return, but the tension eased. Order had been restored. The deviation had been managed. The choreography corrected itself. The judge adjusted his robe and leaned forward, hands folding neatly on the bench. Now, he said, where were we? As if nothing had happened. As if the previous minutes had not been a public sorting, a demonstration of who could be named and who could be moved. The clerk resumed typing. The prosecutor straightened his stack of papers. The defendant swallowed hard and stared straight ahead. The gavel tapped once. Time moved again. She sat, still and silent, eyes on the bench. The fluorescent lights flattened her reflection in the polished wood in front of her. The badge lay heavy against her chest, the clip tugging the borrowed blazer slightly askew. Visitor, misspelled name. A declaration the building insisted upon. The judge spoke to the defendant now, voice firm. Efficient, you understand the charges against you? Yes, Your Honor, the defendant replied. Voice barely above a whisper. She watched the exchange. Not as an observer, but as a student of pattern. The judges leaned forward when asserting control. The slight lift of his chin when the defendant hesitated. The way the prosecutor let the judge do the work of intimidation, hands folded, expression neutral. This was how power conserved energy. From the gallery, she could see everything, the angles, the posture, the way the microphones favored the bench, and left the benches behind her in relative obscurity. She could see how silence was used not as absence, but as a tool. The judge asked questions and did not wait for full answers. He filled gaps with assumption. He smiled when he interrupted, as if kindness could soften the act. She felt heat build behind her ribs, not rage, not panic, something steadier. A pressure that did not seek immediate release. A certainty forming in the quiet space where reaction had been expected and denied. The bailiff returned to his post near the wall. His attention already elsewhere. To him, she had become furniture again, present, but functionally invisible. The defendant's mother sat to rows behind her, hands clasped so tightly her knuckles shone. Every time the judge raised his voice, the woman flinched. Every time the judge smiled, she seemed to shrink further into her seat, as if politeness itself could be weaponized. The judge glanced toward the gallery once more, not at the defendants. Family at her. His eyes flicked to the badge again, and his smile returned, not as broadly, not as comfortably. A smile sharpened by irritation, by the knowledge that something had not gone as smoothly as intended. He addressed the room, but his words were aimed. Just a reminder, he said, that disruptions will not be tolerated. This is a court of law, not a classroom. A few people nodded reflexively. She did not. She kept her gaze steady, her face composed. Silence here was not consent. It was documentation. It was refusal to participate in the fiction that this correction had been about order rather than dominance. The file folder rested on her lap, its bent corner a quiet testament to restraint. Inside it, the record weighted dates, statutes, contradictions lined up patiently. Truth did not need to rush. It only needed to arrive intact. The judge turned back to the bench, satisfied for the moment. The performance continued from her seat in the gallery. She understood something with sudden clarity. The system did not fear disruption because disruption was loud. It feared disruption because it revealed the choreography. It showed the room that what was being called order was simply habit reinforced by embarrassment. Here, resistance was rebranded as disrespect. Correction was treated as challenge. Silence, unless carefully performed, was suspicious. The building taught this lesson efficiently. Stand where you are told. Speak when invited. Laugh when authority jokes. Sit when corrected. Accept the label pinned to you and move on. And if you did not, if you held your ground without spectacle, if you refused to apologize for being accurate, then the system would mark you as the problem. From the gallery, with the visitor badge still flashing its lie under the fluorescent lights, she watched the court proceed as if nothing had happened, but something had. The room had shown its hand, and she had learned exactly how much it would try to take before it realized she was not there to be moved. Second defendant entered, already diminished. The bailiff guided him through the side door with one hand at his back, another hovering near his belt. The young man's wrists were cuffed in front of him, steel biting lightly into skin that had learned to accept restraint as a language spoken fluently by strangers. The cuffs caught the fluorescent light and threw it back into the room in small, sharp flashes, brief signals of control, unmistakable and deliberate. He was young, younger than the room pretended not to notice. His shoulders sagged under the weight of too many mornings that had begun with waiting. His clothes were clean but tired. The fabric stretched thin at the elbows, the collar softened by repetition. His eyes moved quickly at first bench, prosecutor, floor before settling on the floor, as if he had learned that eye contact was an invitation to misunderstanding. The judge's posture changed. Not dramatically, not enough to draw comment. He leaned forward slightly, elbows resting on the bench, pen already in his hand. The smile from earlier did not follow him into this moment. It was replaced by something firmer, more efficient, certainty. The clerk called the name. The judge did not look at the defendant when he said, "Step forward." The defendant did, the chain between the cuffs making a soft, humiliating sound as he moved. It echoed more than it should have. The microphones were unforgiving that way. She watched everything. Not as someone waiting for a cue, not as someone hoping for permission. She watched as a witness watches, recording, cataloging, holding each movement in the quiet place where pattern becomes proof. The judges leaned forward, a posture of interrogation, not inquiry. The way his pen tapped, once against the desk, ticked, then again ticked like a metronome, setting the tempo of presumption. The prosecutor's casual confidence, one ankle crossed over the other, hands resting loosely on his file as if the outcome were already printed on the cover. The bailiff stood to the side, close enough to be felt. One hand rested near the holster, not gripping, not threatening, just present, a reminder that force was always nearby. Even when it was pretending to be irrelevant, the water pitcher on the bench sat full and untouched. Condensation beaded along its glass sides, droplets sliding slowly downward, marking time the room refused to display elsewhere. No one reached for it. No one needed water here. Thirst was not part of the calculation. The judge spoke. You understand? Why you're here today? The question carried a tone that suggested the answer was irrelevant. Yes. Your Honor, the defendant said. The judge did not ask him to explain. He did not ask what he remembered. He did not ask what he denied. He glanced down at the file and began speaking as if narrating a story already settled. You were observed at approximately 11:40 p.m., the judge said, eyes on the paper. In an area known for narcotics activity, officers report you fled when approached. He looked up then, finally meeting the defendant's eyes. Why did you run? The question cut. Not because it was loud, because it assumed guilt as the starting point. It framed fear as evidence. It demanded justification for survival instincts. Shaped by history, the room refused to acknowledge. The defendant hesitated. In that hesitation, the room leaned in. Silence thickened, the fluorescent lights buzzing louder, as if the building itself were impatient. I was scared, the defendant said. The judge's pen tapped again. Tick. Scared of what? The judge asked. The prosecutor did not object. He did not need to. The question did his work for him. The defendant swallowed. His eyes flicked briefly toward the gallery, toward his mother, toward anyone who might translate this moment into safety. I didn't do anything, he said. The judge sighed. Not dramatically, just enough to signal disappointment. That's not what I asked, he said. I asked why you ran. The difference mattered. The judge pretended it did not. She felt the pressure rise in her chest, heat contained by discipline. Moral anger, leashed tightly, paced behind her ribs. This was the moment where assumption hardened into fact through repetition. Where a question was used not to learn, but to confirm. She noted the judge's phrasing. The absence of counsel's voice, the way the prosecutor's pen remained still. Confident that the judge would extract what he needed, the handcuffs glinted again as the defendant shifted his weight. The chain chimed softly, an unwanted punctuation mark. The judge leaned back slightly, pen now resting between his fingers. You know, he said. People who aren't doing anything wrong usually don't run. A familiar line, well worn. Delivered as common sense. She had heard it before, in transcripts, in hearings. In the comfortable language of neutrality that refused to name context. The habit disguised as wisdom. The defendant's shoulders dropped another inch. The judge continued. Voice calm, authoritative. And then we find, he said, that you have prior contacts with law enforcement. Contacts, not convictions, not findings. Contacts, a word elastic enough to stretch suspicion across years, across lives. She watched the prosecutor now. He nodded once, almost imperceptibly, agreement without effort. The bailiff shifted his stance, boots adjusting on the floor. The microphones caught the scrape. The water pitcher remained untouched. The judge looked down at the file again, flipping a page. The sound of paper was loud in the quiet room. Explain that to me, he said, not looking up. The defendant's mouth opened, then closed. He searched for words that would not incriminate him further, for a tone that would not sound offensive, for a posture that would not be read as disrespectful. Every option felt wrong. She recognized the trap. The question was not meant to be answered. It was meant to justify what would come next. From the gallery, she could feel the room's alignment. The judge's certainty anchored everything else. The prosecutor's ease followed it. The bailiff's readiness reinforced it. Even the clerk's typing seemed to fall into rhythm with the pen's ticking. Tick. She tightened her grip on the file without realizing it. The cardboard edge pressed into her palm, grounding her, reminding her that the record existed beyond this performance, that habit could be named, that neutrality could be interrogated. The judge looked up again, eyes settling on the defendant with something like finality. Do you have anything you'd like to say before I rule? He asked. Rule. Not consider. Not here. Rule. The defendant glanced at his mother again. She shook her head almost imperceptibly, tears welling but contained, as if even grief had learned its boundaries here. I just want to go home, the defendant said. The room absorbed the sentence without reaction. The judge nodded once, as if acknowledging a minor inconvenience. Well, he said, pen tapping one last time. We all want things. The cruelty of it was not in the volume. It was in the casualness, the way desire was framed as childish, unworthy of serious consideration, the way exhaustion was treated as entitlement. She watched the judge's hand hover over the file, ready to close it, ready to reduce a life to a procedural outcome shaped by assumption and habit. This was how individual fate was decided here, not by evidence alone, not by law alone, but by posture, by tone, by the comfortable repetition of beliefs that had never been forced to justify themselves. The handcuffs reflected the light again, brighter this time, as if insisting on being seen. She held the image in her mind, every detail, every gesture, every question that cut, not because it sought truth, but because it assumed it. The system called this neutrality. From where she sat, silent and watching, it looked more like muscle memory. And muscle memory, once named, could be challenged. The judge drew a breath to speak again, and she knew without urgency, without doubt, that the moment to remain only a witness was nearing its end. Proceed. The word was sharp, clipped clean of ceremony. It carried no apology, no acknowledgement of the error just corrected, no recognition of the public spectacle that had preceded it. It was authority's favorite maneuver: move on, change the subject, pretend control had never wavered. The judge settled back into his chair, robe draped carefully, folds unmoving now, as if stillness itself could restore command. His eyes did not meet hers again. He stared past her, at the clerk, at the file, at anything that would not require admission. She took her place at counsel table. Not quickly, not hesitantly, she slid into the chair with deliberate calm, the legs scraping softly against the floor. The sound carried farther than it should have, magnified by the room's sudden quiet. Her file opened with a controlled motion, pages whispering as they separated. The counsel table's edge pressed lightly against her fingertips, solid, worn smooth by decades of hands that had rested there before hers. She felt its weight. This was where arguments were made, where voices were expected to rise, then be measured, where the law pretended to be neutral even as it bent under the force of habit. The microphone angled toward her caught the light, its black foam head pointed expectantly, like an eye waiting to be opened. She did not touch it yet. She did not test her voice. She allowed the silence to do its work. Across from her, the prosecutor reassessed. His posture shifted, no longer relaxed, no longer assured. He leaned forward now, elbows close to his body, eyes narrowed in calculation. His earlier confidence had assumed a script that no longer applied. He studied her the way one studies an unexpected variable, trying to decide whether it could be neutralized or had to be confronted. He did not smile. The public benches leaned forward, not dramatically, just enough to signal attention. The room had sensed the shift and adjusted its posture accordingly. Where there had been waiting before, there was now listening. Where there had been dismissal, there was curiosity edged with something like hope. Silence thickened. Every small sound acquired meaning. A chair leg settling, paper sliding against wood, someone inhaling too loudly, then stopping. The fluorescent lights hummed on, indifferent but unignorable, their steady buzz underscoring the moment like static before a broadcast. The judge shuffled papers with unnecessary force. "Let's not waste time," he said. "Counsel, make your point." His tone carried impatience now, a pressure tactic designed to rush her into misstep. He did not look at her as he spoke. He did not ask her name again. He did not apologize for having her escorted like an interloper. Moments earlier, the apology did not come. She did not expect it. Apologies were rare currency here. Power preferred amnesia. It preferred to advance without accounting. She rested her palms flat on the table for a moment, grounding herself. The edge under her fingertips was cool, steady. The file lay open, the bent corner from earlier still visible, a small scar that had traveled with her from the gallery. She began. "Your Honor," she said, voice calm, unhurried. "Before the court rules, there is a procedural issue that must be addressed." The microphone captured her tone precisely. No tremor, no rush. The words entered the room with the weight of inevitability. The judge's pen stilled. The prosecutor's eyes flicked to the clerk, then back to her. She continued, naming the statute, citing the step that had been skipped, the advisement that had not been given. Her language was clean, technical, unadorned. She did not argue morality. She argued law. She built her point brick by brick, each reference placed carefully, each sentence restrained. The judge listened without nodding. His robe remained unmoving, black fabric absorbing light, absorbing responsibility. His face was composed, but the impatience remained, a tension in his jaw that betrayed his irritation at being corrected in public. She finished the point and paused. The silence returned, heavier now. The defendant stood motionless, eyes on her, something like disbelief flickering across his face. His mother pressed a hand to her mouth, breath caught, as if afraid that even breathing might interrupt what was happening. The prosecutor cleared his throat. "Your Honor," he said, carefully, "the state would argue that any omission here is harmless." Harmless. The word landed and spread like a thin lie. She did not react immediately. She let the word sit in the air, let the room consider what it implied, that rights were optional, That procedure was decorative. That harm was something the system defined after the fact. The judge looked at her then directly. A test. She met his gaze without flinching. The power dynamic had shifted, but it had not disappeared. It simply recalibrated, searching for leverage. She responded, measured, respectfully. She said, "The statute is clear. The advisement is mandatory. Its omission is not subject to harmless error analysis at this stage." The prosecutor's jaw tightened. The judge inhaled slowly, then exhaled. He did not apologize. He did not acknowledge the earlier mockery. He did not address the mispronounced name, the visitor badge, the public correction. He changed the subject. "All right," he said, "let's address that issue." The gavel remained untouched. Proceedings moved on. As if this recalibration had been the plan all along, she sat back slightly, hands resting near the file, posture composed. There was no celebration in her chest, no rush of victory, only a cold, steady clarity. Dignity had been reclaimed without permission, not granted, not restored. Taken back by standing where she belonged and speaking when it mattered, the room adjusted again. Accepting the new configuration, the prosecutor took notes now, no longer casual. The clerk typed carefully, aware that each keystroke might be scrutinized. The bailiff remained still, presence subdued. The judge presided, robe still, voice controlled. From the public benches, the lesson traveled quietly. Power could be interrupted, but it would never confess. It would never say, "I was wrong." It would simply redirect, insisting that the correction had always been part of the process. This was how institutions survived accountability. They did not deny the error. They absorbed it, flattened it, and moved on. And as she sat at counsel table, microphone angled toward her, the edge of the table firm under her fingertips, she understood something essential. The absence of an apology was not a failure of the moment. It was its proof. Power rarely admits wrongdoing. It simply changes the subject and expects everyone else to follow. Witness took the stand with practiced ease, uniform pressed, boots polished, hands resting loosely at the edge of the rail as if the barrier were a formality, not a line. He raised his right hand, swore to tell the truth, and sat down already, believing he had. The fluorescent lights flattened him into the same gray palette as the room, bleaching nuance from his face. His eyes moved confidently between the prosecutor and the judge, lingering there, avoiding the gallery. He did not look at the defendant. He did not need to. The story he carried did not require the presence of the person it condemned. She stood. The microphone caught the soft scrape of her chair. She did not adjust the mic. She did not clear her throat. She placed her file on the lectern and opened it to a marked page. A small orange exhibit sticker bright against the white paper like a warning flare. "Officer," she began. Her voice was level, not warm, not sharp, focused. "You testified that you observed my client in an area known for narcotics activity. Is that correct?" "Yes," the officer said easily. She nodded once, as if confirming a spelling, and that observation occurred at 11:40 p.m. "That's right." She lifted the page slightly, letting the exhibit sticker face the bench. "Exhibit A is your incident report. Page 2. Second paragraph. You wrote, 'Subject appeared nervous and avoided eye contact.' Did I read that correctly?" The officer hesitated just long enough to be noticed. "Yes," he said. She did not look at him. She looked at the bench. "Your Honor, may the record reflect the witness's affirmative response." The judge nodded, impatient but compliant. "Proceed." She returned her gaze to the officer. "Officer, how many people were in the area at the time?" "A few," he said. "More than 5. "Yes, more than 10. "Possibly." She let that sit. "Did all of them make eye contact with you?" The officer frowned slightly. "I don't recall." "You don't recall because you didn't note it," she said calmly. "Correct. I didn't note that specifically." She clicked the pen cap once. The sound was small, precise. It cut cleanly through the room. "Is avoiding eye contact a crime?" "Officer," the prosecutor shifted. "Objection," he said, argumentative. She did not turn. "I'm asking for a yes or no," she said. The judge leaned forward. "Answer the question," he said to the witness. "No," the officer said. She did not smile. "And nervousness?" she continued. "Is that a crime?" "No." She nodded again, as if cataloging. "Now, you testified that my client fled when approached." "Yes." "You did not testify that you identified yourself before he ran." "I was in uniform." "That wasn't my question." The officer's jaw tightened. "No," he said. "I did not verbally identify myself." She glanced down at her file, then back up. "Officer, do you carry a body camera?" "Yes." "Was it activated?" Yes, she lifted another page. Another sticker. Exhibit B is the body camera footage. At timestamp 017, the video begins. At timestamp 023, my client begins to move away. Is that correct? The officer SQUINTED. Double quotes yes. At what timestamp do you identify yourself verbally? The officer hesitated. I'd have to review the footage. She waited. The fluorescent lights hummed louder in the pause. Someone in the gallery shifted. Then still. The judge cleared his throat. Counsel, he said. Let's move along. She turned to him then, briefly. Your Honor. This goes directly to reasonable suspicion, she said. I will be brief. The judge's lips pressed together. Proceed, he said again, the word heavier this time. She turned back to the witness. Officer. There is no verbal identification before my client moves away. Correct, the officer exhaled. Correct, she did not give him time to explain. And you pursued him based on your interpretation of his behavior. Yes, an interpretation that included assumptions about nervousness and eye contact. Yes, she clicked the pen cap again once, then she stopped. The pen cap remained still in her fingers. The silence louder than the sound had been. Officer, she said. Have you ever been trained that individuals may avoid eye contact with police for reasons unrelated to criminal activity? Yes. Such as fear? Yes. Such as prior negative experiences? Yes. She let the questions accumulate, stacking them carefully, each one narrowing the space in which his certainty could breathe. And yet, she said, you wrote in your report that his avoidance of eye contact contributed to your suspicion. Yes, she nodded. Once more, no further questions. The room exhaled. The prosecutor stood quickly, eager to reclaim ground. Officer, he began. Based on your training and experience, she listened without reacting. Hands folded loosely at her side, the prosecutor spoke of patterns, of instincts, of the officer's years on the force. The judge nodded along, comforted by the familiar cadence. When the prosecutor finished, the judge looked at her. Anything further? He asked, tone edged with challenge. She stepped forward again. Briefly, she said. She faced the witness. Officer, she said, your training includes instruction on implicit bias. Correct. The prosecutor stiffened. Objection. He said, relevance. She did not look away. It goes to credibility and interpretation, she said. Respectfully, the judge hesitated. Overruled. He said finally, answer, yes, the officer said. And that training teaches that assumptions can influence perception. Yes. She held his gaze now, steady. So when you wrote that my client appeared nervous, that was your interpretation, not an objective fact. The officer swallowed. Yes. And when you assumed his movement away was flight, that was your interpretation. Yes. She nodded. Double quotes. No further questions. She returned to her seat. The courtroom was silent, not the anxious silence of waiting, the kind that follows precision, the kind that settles after something has been cleanly cut. The judge sat back, pen resting motionless on the bench. The water pitcher remained untouched. The exhibit stickers glowed faintly under the lights, small markers of accountability that refused to be erased from the gallery. Eyes stayed fixed on her, not with awe, with recognition. This was not spectacle. It was method. And in that method, the room confronted an uncomfortable truth. The case had not been dismantled by passion or outrage, but by accuracy, by questions that forced assumptions into the open and left them there to be examined. Truth, in this room, had become a contest only because power preferred winning to being precise. Under the fluorescence, with microphones angled toward authority, she had done the simplest, hardest thing. She had asked what was assumed, and she had waited for the answers.